State Capture Commission of Inquiry intends to file papers to counter former President Jacob Zuma's urgent application for the rescission of the Constitutional Court judgment against him. In a stinging majority judgment on Tuesday, the Apex Court found that he was in contempt of court by refusing to cooperate with the State Capture Commission of Inquiry, then sentenced Zuma to prison for a term of 15 months, and he has until Sunday to hand himself over or face possible arrest. To talk more about this, let's bring in legal expert Benedict Phiri on the former president's chances to avoid jail. Benedict, afternoon to you. Thank you for your time. So Jacob Zuma is a man almost 80 years old. He says sending him to prison is a risk to his health, first and foremost, more so now that we are in the COVID-19 pandemic. Is that a solid enough argument to at least get him a reduction of the sentence?
Well, I don't think that argument on its own is solid enough. I think the main thrust of his argument really rides on the dissenting judgment of Theron and Jafta, which basically said, you know, in a constitutional court context, it's inappropriate to issue send a person to jail without actually even giving him a chance, for a suspended order to rectify the matter around why he was in contempt. So I think that's really the main thrust of his argument, to say, well, in ordinary circumstances, a person who goes to jail is subject to the full rigors of a criminal trial process. And in this instance, it's not quite correct from a legal perspective that I wasn't subjected to a criminal trial process, but I was still directed to go to jail without the ability to cure the contempt. And that's why he's asking the Constitutional Court to relook their order and possibly rescind it. And
would that have to be weighted with against the conduct of the former president prior to the judgment? Because the Constitutional Court had at a point said to him, here's an opportunity for you to write to the court to say, in the event of a conviction, what sanction do you think would be most appropriate? Will that matter?
I think that'll actually be the clincher of this application that he's actually bringing. And I think, now that we now see how the matter is unfolded, we can understand what the Constitutional Court was doing in hindsight when the Chief Justice gave those directives or those directions. And I think he will come to rue the day, Mr. Zuma, that, he didn't actually take up the Constitutional Court's offer on why, on furnishing reasons why a custodial sentence may not have been appropriate. And I think the Constitutional Court then was left with no other option but to go on their understanding of the law and without any further input from him. And I've got a feeling that the horse has sailed for him a bit here. The horse has bolted.
And did the former president, as they say in the streets, play himself by refusing to take part in the initial process itself when the application by the State Capture Inquiry was heard by the Constitutional Court? Because he could have, at that point, explained to himself, as he's done now, to say, even in the final straw, if you will, where he left the inquiry without getting permission, he says he had actually gone because he needed to take medication.
Yeah, I think, he does say that he now realizes that he was incorrect in his approach, but he'd acted on the advice of his, legal representatives. But, there is a public policy reason for court orders to be final. And I think, having had the opportunity to address the court on why a sentence to prison may not have been appropriate and missed it, I think it will be very hard for him to then override the public policy reason of court orders being final, and we can't be constantly, in a cycle of never-ending litigation over the same thing.
You touched on this earlier, the idea of how precedent-setting this is legally in the country, and I would imagine, I don't know if you would agree, that a great deal of case law, at least academic study, will have to come out of this moment itself and ultimately what happens with the former president's fate.
I agree with you. I think certainly the dissenting judgment of Theron is going to be the basis for great academic and legal debate going forward. It is unprecedented, as Theron says in her judgment, that a person is sent straight to jail for a contempt. Usually the orders are mixed with a suspended sentence to allow the person to actually cure the reason why the contempt proceedings are being brought in the first place. So this is completely unprecedented in that aspect. And then, we'll have to have a few more contempt cases to test whether this principle that the Constitutional Court has now put in place will survive legal scrutiny in the future.
Does it matter then, Benedict, legally what the former president's supporters are saying is likely to happen in the country if indeed he is forced to serve time as he's already been sentenced? Would a court look at that and say, well, if this is going to put the country at risk of some sort of mass demonstrations, even a degree of rioting in some parts, perhaps that's something to be looked into?
Courts usually make their rulings, in tough circumstances, and especially within the context of this country. This wouldn't be the first time that a court is making a ruling with maybe an unstable political climate or the threat of violence. And, we've seen this constantly in our history as a country. So I think maybe the court might understand the background and what's happening, but ultimately what the court is called upon is to adjudicate the legal principles and the facts giving rise to the legal principles. So I think, they may, consider that, but it's unlikely to play a pivotal role in the decision whether to allow Mr. Zuma to rescind the judgment or not.
Final question. In delivering the judgment this week, Justice Hampepe said that the Constitutional Court had no choice but to jail the former president with the hope that it would send a strong message that the rule of law and administration of justice prevails. Did the judgment succeed in doing that?
I think it absolutely did succeed in doing that. And I think that's the right thing to do in this context. I do understand Justice Theron's dissenting judgment as well, but I think given the nature and the position of the former president and the nature of, the disrespect to the commission and the processes of the commission in view of what the commission is actually trying to establish, I think it is right that the Constitutional Court sends a strong message to future litigants and future participants in legal processes that these things have to be taken seriously and the authority of the court must be respected. You'll recall that the court has no other authority other than its own authority. There's no public opinion, there's no legislature, there's no, so it's important that that respect is actually maintained.
Benedict Phiri, good to speak to you as always.